Yeah, PO. So I'd like to mention again item number 10 and 11 connected, Lordship. This, that absence of PP during trial, that issue, Lordship.
Absence of?
PP during trial.
We'll take up Mr. Ahmed.
Lordship.
We have partly had item 12 and 13.
So probably it may not reach
May not
today.
reach.
So may I appeal also this matter maybe fix next week on in orders column.
Let us
Lordship.
read.
In orders column, I is also pending in my case. Other case, Lordship, he was granted bail, Lordship. Next week, any date.
We'll find out.
Lordship. Oblige.
Yeah, Ahmed. B. Yeah. I'll go later also.
May I please, Your Lordship? Well, item number 2,
Yes, sir.
I think it is better to fix next week, my lord.
Better to fix next week.
A date may be fixed conveniently, my lord.
Is it a fixed matter?
No, not fixed matter. But if it is fixed, my lord,
We'll see, rest will do. Done needful.
my lord,
Right.
it is better to fix because
We don't know how many cases are fixed on which date. We don't prepare the cause list. It will come.
I did one.
Lordship,
May not be possible.
Lordship, there are 3 matters, my 1, 3, and 7, Lordship. Perhaps Lordship will take up item 12 and 13, Lordship.
Hmm?
First, Lordship.
Yes.
Yes. So may not reach, Lordship.
May not, then we'll fix the cases
Yes.
as per convenience of the court, right?
After 2 weeks, Lordship.
We'll see to that.
Oblige.
May I please, Your Lordship, to mention for listing of an IA for orders like for bail.
Madam, pursue before the registry, we don't know. Yes. Can also face, Yes, Mr. Kaushik.
Regarding item number 13,
Hmm?
main issue was here that the child replacement.
Child witness.
Yes. Whether, well, otherwise, my lord, that statement of the child replaced, that was very convincing and my lord, it was recorded properly. Then, okay, my lord,
Learned Amicus has submitted there firstly
Yes.
that the questions put to the child
Yes.
to find out about his mental capacity were sketchy.
Yes, see. But regarding that aspect, my lord, because that paragraph,
Hmm.
below that paragraph, there is another observation of the court, where despite of that, nevertheless, the word is nevertheless,
Huh.
that court proceeded to consider the,
So we wanted you we have read already.
yes,
We wanted you to add further into it.
my lord.
That is already there.
I have placed one judgment that they,
Which judgment?
my lord, P. Ramesh versus State.
Hmm.
My lord, may kindly peruse paragraph A. Is there, my lord?
Right.
One. Generally,
Hmm.
in order to determine the competency of a child witness, the judge has to form her or his opinion. The judge is at the liberty to test the capacity of the child witness, and no precise rule can be laid down regarding the degree and intelligence and knowledge which will render the child a competent witness. The competency of a child witness can be ascertained by questioning her him to find out the capability to understand the occurrence, witness, and to speak the truth before the court. In criminal proceeding, a person of any age is competent to give evidence if he is able to understand questions put as a witness and give such answer to the questions that can be understood. A child of tender age can be allowed to testify if he has the intellectual capacity to understand questions to give rational answer thereto. A child becomes incompetent only in case the court considers that the child was unable to understand questions and answer them in coherent and comprehensive manner. If the child understands the question put to her, him, and gives rational answer to those questions, it can be taken that she is competent to witness examine. But this paragraph here, the judge is at the liberty to test the capacity of the child witness and no pressure can be laid on. Here, meaning thereby, here the honorable court below the presiding officer is the competent authority and he has and it is a subjective satisfaction in my understanding. So there the honorable justice cannot properly put questions, the answers are given, and after satisfying that the answers are sufficient, proceeded to record the statement. So there cannot be no doubt regarding
What are the questions asked?
questions 3 to 4. PW9. But what is the name of your school? Then who all are there in your house? Should you speak the truth today or false? Those are the questions. Then, after approach preliminary questioning, I am satisfied that the child witness can be
Paragraph 6, paragraph 6. Paragraph 5. Okay, this is one part. Then, yes, you want to say something?
Assuming, my lord, these questions are not sufficient. Then also, sports can, my lord, because the lordship has to see the demeanor of the child while deposing the evidence for the court below. In this regard, my lord, we will send judgment, but I'm sorry, we will judgment. There are 58 that has very pinpoint to summarize all the details that is counting several judgment. So it's in one. And it is my lord, state of Madhya Pradesh versus conclusive. Here, my lord, after discussing the seven judgment regarding child witness, here the court summarized the following conclusion. One, my lord. Where it
Yes. Where is the child witness here? PW?
9. Page 29. Like it. We summarize our conclusion as under. One, the Evidence Act does not prescribe any minimum age for a witness, and as such, child witness is a competent witness and is hard. The evidence and cannot be rejected or tried. Second, as per section 118, the Evidence Act, before the evidence of a child witness is recorded, preliminary examination must be conducted by the trial court to ascertain if the child witness is capable of understanding density of giving evidence and the import of the question that are being put to. 3. Before the evidence of the child witness is recorded, trial court must record its opinion and satisfaction, and that the child witness understand the duty of speaking the truth and must clearly state why he is of such opinion. Number 4. The question put to the child in the course of preliminary examination and the demeanor of the child and their ability to respond to questions coherently and rationally must be recorded by the trial. The correctness of the opinion formed by the trial court as to why it is satisfied that the child witness was capable of giving evidence may be gone into by the appellate court by either scrutinizing the preliminary examination conducted by the trial court or from the testimony of the child witness or the demeanor of the child during the deposition and cross-examination as recorded by the trial court. So this court can see, even if the Russell is not satisfied with those questions, to my understanding, this court can see the on the demeanor and the manner which the child witness deposed before the court, whether that can be relied on. So going by the depositions here, the PW9 is coherent and it is clear and is supported by other witnesses evidence.
What about the issue that his statement was not recorded earlier under 161 or under section 164?
And here, because we also that they pointed out that it
I have
was-
pointed out,
Yes.
but what is your additional submission?
My additional submission that on that was never objected.
That is also I have pointed out.
That was never objected.
But
never-
what is the law?
Well, here, because this,
Whatever I have said is not to be repeated.
not to be
Anything fresh.
my submission. Then
I wanted some fresh submission on those points.
this-
Ah.
because here,
Because I have repeated already.
Yes.
I have disclosed. This is the fact situation. 161 was not there. Why IO did not record, he said in the case diary, right? Then thereafter, court expressed a view, and on the basis of an application moved by the PP, he was called invoking power under 311. Prosecution examined because he was brought the witness at the instance of the prosecution. So defense had the opportunity to cross-examine. When the PP moved the application, defense had no objection. Right? He was cross-examined accordingly by the defense. This part is okay. I wanted to you to address that when a person's statement was not recorded under 164 earlier or under 164, meaning thereby there was no previous statement of a witness, be it a child or be it a old man, be it a able-bodied man, how his testimony is to be appreciated by the court. That is what, these are facts. I wanted to infuse submissions on that. When there was no previous statement of a witness, when he is called as a witness during the course of the trial, he cannot be contradicted. His statement cannot be corroborated. How his testimony is to be appreciated by the court? This is the precise issue I asked. Facts repeated are not to be repeated. That I have already found, which I have just said. The question is that when there was no previous statement of a witness, and the witness was brought during the course of a trial by the court on the basis of an application moved by either by the prosecution or by the defense under section 311 CRPC. Then this witness cannot be contradicted with his previous statement by the defense. So defense is handicapped, right? And if there is no 164 statement, so court is also handicapped to compare his previous statement and his testimony before the court for the purpose of corroboration. And defense also at the same time is also handicapped to have an opportunity to contradict his statement. So in such situation, how the testimony of that particular witness is to be appreciated by the court?
That as well I-
That is the only issue, legal issue. Because everything goes, because defense is most of the time is successful. In trial, in the trial system, in our trial system, that witness hostile first, then prosecution does not know how to do it because of lack of experience. Secondly, defense sometimes gets successful because they contradict, and by way of putting the previous statement and duly proving it, they brings out the contradiction or omission. As a result, the case, when at the first look, beyond all reasonable doubt, then after contradiction and all, omission, it becomes a case of not beyond reasonable doubt. The question here confronting us is that how the testimony of such a witness is to be appreciated by the court. He is found consistent. He has stood the test of cross-examination. But still, that point, things which have been deliberated are not to be repeated. Am I clear?
Apart from this.
For that only you were granted the opportunity. I
maybe
thought that our research will be less,
Maybe.
but it remains stagnant.
I maybe misunderstood Mello because I thought these three questions were there regarding those questions. I understand was pointing out those things one.
No, the legal issue is that.
Apart from this child witness also, other witnesses, correlation,
Since he is the trump card,
is a trump card, the.
right? So his thing is to be appreciated, is required to be appreciated by the court. Burden is on us. We thought that he will lessen some burden. But burden remains burden
Why that is?
as on date. No. Oh, really? It doesn't have a problem. So, what was it? When portal is also needed to find collaboration. You straight away come to that. Otherwise, prosecution through some witnesses during the trial can name some witnesses more, right? X, Y, Z. ABC is examined. A will say X was there, Y was there, and Z was there. Then prosecution will move an application, whatever lacuna was in the investigation, they will move an application X, Y, Z according to A was there. They will come. They will depose whatever lacuna is there, fill up all the gaps. Have you seen the film of Amitabh Bachchan and Dharmendra? Huh? Do or do Panch. You see, both are stock witnesses. They give evidence in trials. Every fortnight. And they always stand the cross-examination. Beautiful movie. You see, they are stock witnesses. Anything trial, prosecution will bring them, defense always fails to bring out any contradiction. They are so perfect in their examination. Testimony. Right? See that movie, it is a very beautiful stock witnesses. The child is not a stock witness, but this is the question, legal issue. Yes, Mr. Anybody can answer? No. Let me just. Yes. We close then. We have to do the work if possible.
So,
No problem. There is no time. My sim sister will not be there from next week. No time for you to research, come back. We'll close.
can we fix tomorrow?
Heard. This very corridor. Learn at the mic script for the appellant. And Mr. R. Kosik. Learn an additional public prosecutor for the respondent state. Arguments are heard, as many is reserved. Thank you, Doctor. Yes, did you find out the
Yes,
mistake?
well, it's, yes, there is nothing on record to my lord show why he did not appear, nothing, because summons were sent, my lord. But then, nothing, why he did not appear.
Any report?
Well,
Report, service report?
yes, service report is there.
What is the report? What does the report says?
Behind that summon notice written that my lord received late, kindly fix another date,
Received late.
Lately, man.
kindly fix another date, and my lord, 161 was recorded of that injured person. Otherwise, there is nothing.
We can't look into it.
There was
So that part will go, my lord. That so far as that conviction of 2 years for this person it goes. That will not be.
Because if the prosecution is required to produce the best evidence and the material witness. He was a material witness. That could have been the best evidence.
Yes,
Others can corroborate.
yes, of course.
But if the sun is not there, how can the planet move around? That goes. Because the region is inexplicable why the prosecution did not bring the material witness. So far as one injured witness is concerned. But Mr. Datta, that ask for the other one is difficult.
Other is very difficult, man.
Let us have.
That's very difficult to understand. That. We'll have to-
Let us have the witnesses once.
Yes, my lord, the PW one, my lord, page 8, my lord, that is the informant, my lord.
Let us read.
He is of course a hearsay, my lord. He heard about the incident.
Let us read.
Yes, ma'am. Yes, ma'am. I know the accused, victim Swananda Uria is my brother.
This man is there as a witness.
No.
Savananda.
Yes, Swananda is there. Yes,
Okay,
he is a
okay.
victim.
He is
yes.
PW?
Yes, he's PW two.
Okay.
I also know the injured Jiban Masi Barla.
He is missing.
He is missing. Incident took place about 7 months back, at about 6:30 p.m. At that time, I was in my house. My father came to my house and told me that the accused caused injuries to my brother. So he got the information from his father. Swananda in the Tangi house of Mansuk Nag near the Manmao River. I immediately rushed to the spot and saw my brother with plethora of blood. I saw cut injuries at the back of the neck, waist, and the ribs of my brother. At the time, another injured Jiban Masi came to the spot, and I also noticed cut injuries in his forehead. On being asked, he told me that the accused caused injuries to him. Thereafter, I called ambulance, 108 ambulance, and both of them were taken to Margarita Hospital. Thereafter, as injuries are serious, Dr. Margarita Civil Hospital referred both of them to MCH Dibrugarh for better treatment. That my brother was admitted for about 8 days. On being asked, my brother told me due to old grudge, the accused caused injuries to him. Thereafter, on the following day of incident, I lodged an FIR at the Azhar at the so-and-so. PS Exhibit 1 is the Azhar. 1 is my signature. Later, police seized the machete on which was used in the conducting the crime. Exhibit 2 the seizure list and 2 is the signature. Cross-examination. I did not witness the incident on my own. I have not asked my father whether he had seen the offense committed by the accused. I have not seen the accused.
Father, you witness?
Father, my lord, Joseph is, my lord, not a witness, my lord. Joseph is not a witness, my lord. He is Joseph Oria, my lord. Police recorded my statement. It's not a fact that the police did not record my statement. It's not a fact that I have not stated with the police.
Joseph
My father
Oria.
had informed me about the incident. The house of Mansukh Nag and Tanti Ghar are the same campus and adjacent to the house of Mansukh Nag. In the house of Mansukh Nag, Mansukh Nag himself and his mother and wife and elder brother Manuel Nag present. Mansukh Nag and his family members were present at the time when I reached the place of occurrence. I have not asked Mansukh Nag and his family members of the incident how the incident took place. That there was bad relation and enmity prevailing between the accused and the victim, and also along with me. It's not a fact that the accused did not assault the victims. It's not a fact that due to prevailing old grudge, we filed the case against the accused. Adjacent house of Mansukh Nag and Sam Hora, Nakodin Tuti, Dayal Bengra, and Hemsing Barik, Preman Hans. I have not seen a single person of the above stated neighbors at the place of occurrence. Seizure list was prepared in my presence today. Today I have not seen the seized machete in the court. The machete has been recovered under a flower bush. The police has not recovered the dao in front of me. I had no personal knowledge where from the dao was recovered. It's not a fact that the police obtained signature on a blank paper. The ejara was written as per my version. It's not a fact that the accused did not commit the offense. Now PW2, page 10.
Yes.
Is the victim. Sonanda Oria. I know the informant of the accused in the incident case. On the day of the incident, that is in the month of October 2015, at about 6:30 p.m., when I, along with Jiban Barla and Mansukh Nag, were sitting in the Tangar, situated in the house of Mansukh Nag. Well, Mansukh Nag is the PW7, who is also a witness who has been deposed. At the side of the fire and making fishing nets. At that time, I saw Santokh Hans coming towards me with a Kalam Kotari dao and inflicted cut injury on the left side of my head, just above my left ear and neck, and I fell down. The accused also inflicted cut injuries on my back, waist, and on my rib portion. For some time, I remained unconscious, and as I awoke, I somehow managed to go to my house, which is situated nearby. After I reached the house, I lost consciousness. I regained my senses at the Margarita Civil Hospital and could learn from my family members that I was shifted from my house to Margarita Medical Hospital by my family members through 108 ambulance service. Again, from the Margarita Civil Hospital, I was shifted to the AMCH Dibrugarh for further medical treatment. I remained completely bedridden at the AMCH Dibrugarh for about 8 days. After my discharge from the AMCH Dibrugarh, I returned back to my house. Jivan Barla, who was also present at the time of occurrence, along with me, was also taken to the AMCH Dibrugarh for treatment, and I noticed that the accused had also inflicted cut injuries on the forehead of Jiban Barla. Jiban Barla had stated to me about his injuries and about the incident. I reached home from AMCH Dibrugarh. I was accompanied by my father Joseph Oria and my one elder brother, also named as Joseph Oria, when I was undergoing treatment at AMCH Dibrugarh. In cross, it says, the Tangar has only one single room and door. The house was partly dark apart from the fire. The person who was sitting nearby, their faces can be identified, but the persons who are far away, their faces cannot be identified. At the entrance of the Tangar, there was no fire. The fire was situated in the middle. The fire was placed over the tin plate and the flame of the fire was feeble. While we were surrounding the fire, the entrance of Tangar was in my back side, but nearby also. It is not a fact that I did not notice the person who inflicted dao blow to me due to partial darkness of the room. After sustaining injuries in my head and neck, I became unconscious and I did not see who inflicted the other blows. It is not a fact that I did not see who caused the injury to my head and neck. It is not a fact that I have no previous enmity with the accused. It is not a fact that we were intoxicated, we were in intoxicated state at that time. I have not seen to whom the accused inflicted injury apart from me. Jivan Barla was also beside my bed at the AMC at Dibrugarh, but in which ward of the hospital where we were admitted, I cannot say. It is not a fact that Jivan was also admitted beside my bed at the GMCH, AMC at Dibrugarh. The day of the incident, Jiban Barla came to me and informed that he was also inflicted cut injury by the accused. It is not a fact that Jiban Barla did not tell me about the injury sustained by him. It is not a fact that when I was unconscious and regained my consciousness at Margarita Civil Hospital. It's not a fact that the accused did not inflict cut injury to me. I was interrogated the police and I've stated as I've deposed today. It's not a fact the accused did not enter the Tangar and committed the offense. Now, PW3 is again a hearsay evidence. She's one Dulari Horo. She says that I know the accused, Champak. I also know the victims. The incident took place in the month of December last year, about 6 p.m. At the time, I was bathing in my house. Then I heard a bamboo cutting. After a few minutes, I heard a sound ma. Then I came out from the house and saw Swanand Uria with bloodstain on his whole body. On being asked, he told me that the accused Chantak had caused cut injuries to him. Thereafter, I saw Jiban Masi Barla with a cut injury in his forehead. Later, the accused person was apprehended with VDP and handed over to the PS. Later, police came to record my statement. I cannot remember the date of occurrence. On the day of incident, I went to the school. At the time, my husband was only present. It is not a fact that injured Swananda Oria has told me that the accused caused him injury. Swananda Oria is my next door neighbor and the accused Santak Hanse is residing far away from the house. There's a close intimacy with Swanand Oria and prevails a good relation with the injured. I have not seen how the incident took place. It is not a fact that I have given false evidence in favor of Swananda Oria. I have no personal knowledge how the incident took place. I have not stated with the police that I saw Jivan Masi Barla having a cut injury in his forehead. I was not accompanied the VDP person to apprehend the accused. I have no knowledge that the VDP had apprehended the accused person. I have not stated in my earlier statement before the police how the accused was apprehended by the VDP and from where the accused person was apprehended by the VDP person. It's not a fact that I deposed falsely. PW Block 4 is one Sam Boro. He is also a hearsay witness. I know the accused, Chantak. I know the victims. The incident took place in the month of December last year at about 6:37 p.m. At that time, I was sitting near the flame in my house after bath. Then I heard of bamboo cutting. After a few minutes, I heard a sound ma. Then my wife came out from the house, and after a few minutes, she returned to my house and told me that she saw Swananda Oria with bloodstain in his whole body lying in his courtyard. Later, I came to know that the accused caused injuries to Swananda. Ross, he says, I cannot remember the name of the person from whom I came to know that the accused caused injuries to Swananda. I have not seen how the incident took place. 5 is another hearsay evidence. Is one Nikodam Turti. I know the accused as well as the injured Swananda Oria. The incident took place about 9-10 months back at about 6:37 p.m. At the time, I was present in the meeting in another village. At the time, I was informed by Paulus Bangra over my cell phone that the accused assaulted the victim with a machete and caused injuries to him. I immediately came to the house of the Swananda Oria. I found Swananda lying in front of the door with injuries. He was able to speak, but he was. On being asked, he told that the accused caused him injury by assaulting him with a machete from the backside when he was sitting at Tangighar of Mansukh Nag. Notice one cut injury in his neck, one cut injury in his hand. Thereafter, the villagers sent him to hospital by 108. Ambulance later police case. Police apprehended the accused and handed over him to police. The weapon used in committing offense was seized by the police and prepared in the seizure list. I put my signature there on as witness. 2 is the seizure list, 2 is my signature. My statement. I have no personal knowledgeable incident to how the accident took place. Joseph Korea and Maria Korea, parents of the victim, are present at the time of incident. Due to darkness, I cannot say exactly how many numbers of injuries sustained by Swananda. It is not a fact that injured told me that the accused caused injuries upon him. It is the seized thou has been shown by Matthias the type of measure are generally used to cut jungle in village areas. Generally, this measure have been found in everybody's house. I do not know the English language. I cannot say what has been written in English in Exhibit 2 by the police. I have not seen the seized dhow in the court today. It is not a fact that the police has taken my signature in white paper. It's not a fact that I, alongside villagers, have blamed the accused and handed him over to the police. Then, my lord, PW6, one Martias Hans. I know the accused as well as the injured Swananda Oria. Incident took place before Puja last year at about 6:37 p.m. At the time, I went to with the Dihang River to catch fish. On my return to home at about 10:30 p.m., then my wife Meena Hans told me that the accused caused cut injuries to the victim, injured Swananda Oria. After return from hospital, I met the injured Swananda and I noticed one cut injury in his neck and other parts of the body. After committing the offense, the accused shelter in our house, and I took the measure from the accused kept inside our homestead, under the bushes. When the police came, I handed over the measure to the police. Police prepared the seizure list and put my signature there under the witness. 2 is the seizure list, 2, 3 is my signature. Police recorded my statement. I have no personal knowledge how Swananda got sustained injuries. I was not present at the place of occurrence as well as my home. At that time, I had gone for netting fish. Santak Hans reside Bagmara Gaon, which is about 1 kilometer distance from my house. Santak Hans is my own relative. That's why I know him. I have seen 2 numbers of injuries on Santak's body, Swanand's body. I cannot say the length, breadth, and depth of the victim. I cannot exactly say exactly whether the injuries are cut injuries or blunt injuries. It is not a fact that the dhow belongs to me. It is a fact that I have concealed the dhow. I have not seen the dhow today in the court. I do not know English. That's why I cannot say what has been written in the English, written in English in Exhibit 2 by the police. I do not remember when the seizure list has been prepared by the police. It is not a fact that police obtained my signature in blank paper. Now, PW7 is Mansukh Nag, in whose house perhaps this took place there. Now, he's an eyewitness. I know the accused. I know both the victim, Swananda Oria and Jiban Masi Barla. Incident took place 11 months back at about 6 p.m. At that time, I, along with Swanand Oria and Jiban Masi Barla, were the Tangi Ghar, sitting beside fire, taking the warmth as the day was cool. At that time, the accused persons came to Tangi Ghar and without any reason, assaulted Swananda Oria and Jiban Masi Barla with a machete. Swananda sustained cut injuries in neck, waist, back, and Jiban Masi Barla sustained cut injuries on his forehead. After the incident, both the victims ran to their respective houses. Police came, interrogated me, and recorded my statement. Except the flame, the entire house was dark. There was only one door in the Tangi Ghar. The entry door was dark. It is not a fact that the accused had entered Tangi Ghar and caused injuries to the victim. The accused's house is far away from the house. It is not a fact that the accused did not enter the place of occurred and commit any offense. It is, I do not know who informed the police. It is not a fact that the police did not interrogate me. Except me, Swananda Oria and Jiban Masi Barla were present at the Tangi Ghar. Except me, Swananda Oria and Jiban Masi Barla were present at the Tangi Ghar. It is not a fact that I have deposed falsely before the court today. Now, PW1 is, PW8. I know the accused. I know both the victim and Swananda Oria and Jiban Masi Barla. Incident took place about 11 months back, about 6:30 p.m. At the time, I was in my house. At the time, I was busy cooking food. The accused came to our house and he shouted outside my residence saying that he had taught a lesson to somebody. Thereafter, he washed his hands and legs in a tube and asked for water. He also threatened to kill me so I did not come out. Instead, I sent my daughter to give him water. That the accused told that he will take meal in our house. I refused to give him meal. Thereafter, he told that he caused injuries to Swananda Oria and Jiban Masi Barla. Thereafter, he left our home. Later, I came to know that the accused persons cut injuries to Swananda Oria and Jiban Masi Barla. Police came, interrogated me, and recorded my statement. I have not seen how the injured sustained injuries. Chantak Hansa is not acquainted with me. It is not a fact that the accused did not shout outside my residence saying that he had taught a lesson to somebody. I did not file any complaint with the police regarding threatening given to me by the accused to kill me. It is not a fact that the accused did not come to my house and he told that he caused injuries to Sunanda Odi and Jivan Masibarla. It is not a fact that I deposed falsely with the court today. Now, PW9 is a doctor which I'm in. Now, I was at present working. Oh, I'm sorry, I'm at present working as resident surgeon surgery at AMCH. On 28/10/15, I was posted as MO at AMCH casualty ward. At 12:55 AM, I admitted Jivan Masibarla, 28 years male, and son of Manuel Verma. On admission of the said person, I found 3 centimeter fresh pre-stitched wound on the left forehead. The patient was primarily treated at Margarita Civil Hospital.
Where is the medical evidence of the,
Yes, stable. It's page 57, my lord. 57 is Sonanda Odia, 55 is this, my lord, Jivan Masimal.
no, who deposed about his evidence, injury?
My lord, this is a
Savanand?
this is a doctor, my lord, who treated them at AMCH in the casualty ward.
Huh?
AMCH casualty ward, my lord. He was the person who attended. him.
Huh, he's, okay.
Well.
Okay. Understood.
My lord. The patient was discharged on the same day on advice, page 21, my lord.
Resident doctor, AMC.
AMCH. He was in the casualty ward, he says, my lord.
EMCH. He
Yes.
initially went to Margarita.
Yes, therefore he is referred to, my lord, AMCH,
Huh?
where he attended.
Okay.
So, well, he found that the pre-stitched wounds, well, the wounds he did not stitch, well, it was already stitched.
Maybe Margarita.
Yeah, Margarita may be possible.
Hmm.
The injury of the patient was primarily treated at Margarita Civil Hospital. Nature of injuries is simple and fresh. No police scent was provided with the patient. The patient was discharged the same day after advice. Exhibit 3 is the medical report and 3.1 is my signature. On the same day, I admitted one Swananda Oria, 33-year-old male, and found following injuries. A fresh pre-stitched wound size 8 centimeter extending from the back of neck below the left ear up to the cheek. A fresh pre-stitched wound of size of 3 centimeter over mid part of the back region. A fresh laceration of size 2 into 1 into 2 cm over back of left arm. 2 cm fresh pre-stitched wound over back and left shoulder. 5 centimeter fresh pre-stitched wound over left lower back. 3 centimeter fresh pre-stitched wound over back of left shoulder. CT scan of cervical spine shows minimal displaced fracture in the spinous process of Curvix vertebrae. CT scan of the brain shows soft tissue swelling over left thigh parietal region and old huge granulomous region in the left parietal lobe. The nature of injury is grievous. The patient was admitted and discharged on 4/5/11/2015. Patient was not accompanied by police. Patient was brought by Joseph Oria, the father of the patient. Exhibit 4 is the medical report. 4.1 is my signature. Police requisition was not received. I did not see the identity card of the deceased. I saw reports of the injured at Margarita Civil Hospital, but I did not see any report in these documents. Since the wound was pre-stitched, so I cannot opine whether the injury was caused by sharp weapon or not. Usually, if a patient is referred from civil hospital, it has been mentioned in the ML book. I do not know whether police sees the exact copy of the ML book or not. I do not know, did not mention the age of the injury. Fresh injury means sustained in 6 hours. The injury exhibit 3 may be caused by falling. The injury exhibit 4 may be caused by accident with heavy force. Now, Jatin Saikia is the IO, is PW 10. On 28/10/2015, I was posted the Margarita PS and SI as SI, and on that day, the officer in charge, Hiranyo Kumar Bora, received one written Ezahar from James Oria, which was registered as Margarita PS case number so-and-so of IPC and entrusted me to investigate the case. After taking over the charge of the investigation, I went to the place of occurrence, visited the same, drew a sketch map, and recorded the statements of the witnesses, including the complainants. On reaching the place of occurrence, I find that the accused was apprehended by the villagers. I interrogated the accused orally. The accused stated that dao used in the incident has been concealed near the Pokrajhora plant in the house premises of Matthias Hanse. Accordingly, we went to the place along with the accused and recovered the said dhow and seized the same. I prepared the seizure list in the place where from the dhow was recovered in presence of the witness. Thereafter, I brought the accused along with the seized article to the police station and recorded the statement of the accused. After due formalities, I arrested him and forwarded him to judicial custody. After returning the victims, injured victims from AMC Dibrugarh on so-and-so, I interrogated the victims with Sonanda Alva and Jivan Masi Barla. Later, I collected the medical report of both the injured, and on finding sufficient materials against the accused Santok Hansa, I submitted the charge sheet under section 324, 326, and 307 IPC. 2 is the scissor list, 2-4 is my signature, 5 is a sketch map, 5-1 is my signature, 6 is the charge sheet. I visited the place of occurrence the day of registering the Jaha. It is not a fact that I read over the contents of the seizure list to the seizure witnesses. It is not a fact that I recovered the seized dhow as led by the accused person. There is no blood stain on the seized dhow. I have not.
Who else
mentioned-
said regarding recovery of dhow?
They said that it was the
Which one, the other witness?
other witnesses. Say,
Somebody said he concealed.
yes.
PW6.
PW6. And IO says it was recovered from his premises.
Hmm?
Premises of PW6. I have not mentioned in the confessional statement as the owner of the seized dhow. The seized dhow belongs to the accused Santak Hanse. I have not sent the seized dhow to FSL for examination. It is not a fact that I cannot ascertain as to whether the dhow was used in the commission of offense. I sent the accused for recording statements on 164 CRPC confession statement to the court. As per my diary, he declined to confess to the court. James Hanse did not state before me the injured Sonanda Oria stated before him that the accused assaulted him due to old grudge. PW Sonanda Oria did not state before me that he became unconscious after he assaulted by the accused person. PW did not state before me that he met Jiban Masi at AMC Dibrugarh while he was admitted there and saw the injuries in his forehead. PW Sunanda did not state before me that while he met Jiban Masi at AMCH, Jiban Masi told him about the incident of his injuries. PW2 also did not state before me that on the day of incident, Jiban Masi Barla came to him and informed him that he was also inflicted with injuries by the accused person. Dulari Horo did not state before me that she saw a cut injury on the forehead of Jiban Masi Barla. Nicodim Tuti did not state before me that Folas Vangra informed me about over phone that the accused had caused injury to the victim with dhow. He stated before me that he saw Sunanda Ore lying in front of the door in injured condition. The accused caused him injury when he was sitting at Tangighar. 6, Matthias Hanse did not state before me that Sunanda, after returning from hospital and saw cut injuries on his neck and other parts of his body. I recorded the statement of PW6 before Sunanda returned from hospital. PW7 Mansukh Nag did not state before me that he saw injuries on the neck and chest of Sunanda and the injuries on forehead of Jivan Masi Barla. PW8 Meena Hanse did not state before me that the accused threatened her for her life. PW8 stated before me that she came to know that the accused assaulted and Jivan Masi Barla and Sunanda Oria. It is not a fact that the accused was not involved in the case and I did not investigate the case properly and file the charge sheet against the accused persons. Now, my lord, 313 statement, my lord. James Oria has deposed around 6 p.m. on the day of the incident. His father informed you that
All admitted.
all admitted. He says that I assaulted him after I persuaded him, but he did not listen to me. I assaulted him. I assumed it weapon in my hand to be a lathi, but I later found it was a dhow. Then the second one, my lord, he said, yes, he told the truth. Then similarly, my lord, yes, he has told the truth. All my lord admitted, my lord. What you have to say regarding the incident, my lord? Question number 7, my lord. Mansukh Nag told me to kill Swananda. Mansukh Nag told me to kill Swananda. So the incident took place in the house of Mansukh. And he says, Mansukh Nag told me to kill Swananda. Jiban Masi Barla arranged for girls for Swananda who committed bad acts with the girls. Mansukh, Swananda and Barla all together were cutting bhang and ganja. At about 11 p.m. when I was in the house of Matthias, Barla and Swananda came to assault me. On the following day, I went to the house of Mansukh and on being asked, he told me that Swananda and Jiban Masi Barla were sitting in the Tangighar, situated behind the house, and he also asked me to kill them. Only for the reason I assaulted them, I have no witness except Mansukh.
There was no suggestion to that effect, but
No, my lord.
you seem to be alone. Neither your wife nor your children live with you.
No, my lord, no, no,
Huh?
no. No, they don't stay with him.
Hmm.
He was, well, at that time, about 50 upon year.
Fracture was there, so 325. Now, what about the reasoning recorded regarding 307?
My lord, man. Para, my lord, para 26 onwards, may starts, my lord. Sorry, my lord, sorry, para, it will be para 39. So quoted, my lord, 30, 40, my lord, para 39 last. In the present case in hand, 40, page 48. In the present case it has in hand also, the accused in his 313.
Page 40?
Page 48, man. Paragraph 39, 40. sorry. Paragraph 39, there's a discussion of a order of the Honorable Supreme Court. And then, my lord, in the present case in the hand also, the accused in his 313 statement given to the court confessed that he inflicted cut injuries by a dowel to the two victims. He also admitted and stated that the witness was telling the truth. Moreover, the admission in 313 statement of the accused and the evidence of the PWs are corroborating each other and a completing picture of the circumstance and prosecution story. The manner of committing offense, the positions of the injuries, and the nature of weapons used establish beyond doubt that the intention of accused was to commit murder of Swananda Odia. It was a settled principle of law that in order to prove a person guilty of attempt to commit murder, an intention or knowledge of the committing murder and doing an act towards it are to be present, that there must be mens rea followed by actus rea, and the actus rea must be more than a preliminary preparation. In the present case in hand, I find that both the mens rea and actus rea are present in the case at the time of committing offense with the accused. The circumstances and evidence show that the weapon of offense is a dowel with an instrument of cutting, hence it comes under the purview of dangerous weapon. The medical report of the victims when Solanda area showed the injuries to be grievous, and the medical report in the injured, Jivan Masi Barla, showed the injuries to be simple. From the evidences, discussions of the statements of under section 313 of the CRPC, I find the accused caused grievous hurt to the victim Sunanda Ode with the intention of knowing the consequences. And the accused, hence, caused offenses voluntarily, and hence the second part of the 307 of IPC attracts the section, sorry, part of section 307 IPC attracts as the accused caused hurt to the Surrender area in execution of his intent. From the medical report exhibit 3, I find that the prosecution failed to prove beyond all reasonable doubt the accused attempted to commit murder of the victim, Jiban Masi Barla, and according to exhibit 3, the injuries of the Jiban Masi Barla are simple. But from the evidence of section 3 and certain statement, the accused the same caused by Dow, hence the prosecution failed to prove the offense under section 326-307 of the IPC against the accused for the said victim, Jiban Masi Barla. And from the above discussions and reasons, I found that prosecution is able to prove the ingredients of offense under section 326, 324, 26, 307 of the IPC against Santokh Hans for the victim Sunandaria, and is able to prove the ingredients of section under section 24 of IPC against the victim Jiban Masi Barla beyond reasonable doubt. Now, the medical report, my lord, Lakshman, find two medical reports at 55 and 57.
When the injured was examined,
But the, Dr. Miller,
no, injured,
yes, who examined, Dr. Miller? Or
injured.
I mean, examination by whom, doctor? Or the witness? Examine the
Position.
PW two, his,
Period two.
16, 116, 30th May.
Yes.
So far, Miller, there's 313 statements are concerned, Miller. Though Miller, there's an admission, I find it very strange because Miller, earlier he refused to confess. And suddenly what changed because though again, Miller, as far as Mansukh Nag is concerned, he said that Mansukh Nag instigated because there's no cross-examination, no, he was not even questioned on that issue. That is there, Miller. So, Miller, but then this, Miller, why this statement came, Miller, 313 statement is totally, Miller, unexpected, Miller, I would say, because earlier he, Miller, admittedly he refused to confess. The police said he did not confess. No, Miller, he also says, Miller, that he because so far the injury, Miller, the evidence of
Thought
the
it is a lathi.
he thought it's a lathi. He thought it's a lathi.
He doesn't know the difference.
Doesn't know the difference. But later on in the second part, he said that you came along with the second question. You came with this thing that now he said, yes, it is true. But here he says it's lathi. PW, second question. Sonanda Warrior, one of the two victims, deposed that on so and so and so. You proceeded
Then,
towards.
after that, your post-occurrence conduct,
Yes.
you went to a house.
Yes.
House of PW6.
Yes.
He said he came to us. You are not denying it. PW8, that man's wife,
Yes.
corroborated. You did not
I did
ask
not.
her,
I did not.
meaning thereby you went there.
My lord.
With a dao.
Yes, true, man.
So if not cross-examined on those points.
Yes.
Then it is true.
True, man. In fact, so far the injuries of the concern, my lord.
It
He
is to
says,
be
my lord,
accepted.
my lord,
So far PW6 and 8 is concerned,
my lord.
after committing the
Yes.
act, you went to the house of PW6. He said, and he said, he took the machete,
Yes.
kept inside under the bushes. He handed over the machete. Let us see the seizure list.
Seizure is page 53, my lord. 53. SI Jotin Saikya Margaret do hereby seize the following descriptive doubts
13 Secretary seized
on being dated and produced by the accused person named Swenson.
from the premises of Matia Hans, where, wherein is hiding Matia Hans from the, on being late. What did he say? On the IO's testimony was put to him.
Yes, no, I used to.
PW. That was not put to him. IO is
IOSPW 9, my lord.
9,
9 or 10. I'm just
not put
sorry, my lord, 10, my lord, 10. 9 is the doctor.
313, not put.
Not.
Huh?
313 was not, my lord. 313. was-
Yes, Mr. Kaushik.
Not put. Not put. PW7, PW5.
There is a fault on the part of the court.
PW7. That was not put. Even though that confessional statement was also not
Confession not recorded, I think.
record, but that was not brought on record. My lord. That was
No, confession was not recorded.
No.
164 is not recorded.
was not recorded.
IO said,
Yes, sir.
I think.
No, I said I sent the accused for recording statements once you said. Yes, sir. I sent the accused. Page 24. But as per my diary, he declined to confess with the court.
Decline to confess.
confess. No, with regard to the recovery also, that statement, what he stated exactly and how, that was also not.
I know
proved yet.
the.
Because there is a requirement that he has to prove that statement. But that was also not proved. Just he simply said that the accused of,
Therefore, he was
accompanied-
female and male can you take. Yeah, obviously, there are only you for means. There is an element of extrajudicial confession also.
well, but that was not, that was not proved, my lord.
What proved? Who will prove?
My lord, that extra,
PW six will prove only and eight will prove. And you did not ask anything.
no, we did not ask, my lord. That was then.
Ah.
We did not ask. We did not revert back to that. That was
And
there.
there was no pressure from PW six and PW eight. They
That
are
is
not
also-
person from authority.
That is also not brought.
There was absence of no police personnel.
There was no, that was not.
They are no person from authority that
Those.
that they can give promise to you.
Yes. No, nothing of that.
That is also there.
Nothing.
Your. In fact, he was your relative.
Yes.
That is why you took shelter there.
Yes.
Huh?
Yes, sir.
So your own relative is turning against you.
Yes.
Mr. Dasgupta, you can go home. I don't think it will be possible. Hmm. So 307. Now question is, injured witness. He is like a prosecutrix. The status of injured
Yes,
witness
yes.
is at a higher pedestal,
Obviously.
right? Then there is an eyewitness,
Then the nature of injuries also.
adding masala to it,
My.
adding weight to it.
Mhm.
Then there was extrajudicial confession, PW six and PW eight. You took shelter. There, both husband, wives, persons are corroborating each other, and there was no cross-examination. The injury are in conformity with Dow. Then these circumstances appear to be enough, sufficient.
The position of the injuries also, the part of the body,
position.
part of the body. which-
Ah. Then evening hours, there was lighting. It is not that, and you were known to it.
Known people, no, yes.
And then admission by the brothers,
Victims.
brother of the victim and the victim. We had enmity. Enmity means that enmity perhaps.
Yes.
The previous day
Ah,
is enmity. There is enmity. So there is a cause for you also.
Yes.
There is animosity. So after keeping this aside, we examine 313.
Well, even if 313
It's
goes,
a nil.
well, but even if the 313 is not, well,
Last nail in the,
True.
so the question remains 326 and 305. 10 years or life?
Life, man.
Yes, Mr. Kosa.
Here, all the prosecutors pointed out all those ingredients.
There is a mitigating circumstance, 313 admitted. No criminal antecedent. He had the opportunity to hit in the head also. Yes. Out of 5, 6, see the injury report. I don't think 3 is 3, in fact 2, 3, 5, 6, page 21. Mid part of the back region. 3 cm
It-
after stitch. So it will be slightly lesser. Laceration, that could be by fall also. He said, doctor,
Yes, Dr. Sethi.
somewhere. 3 may be caused by falling. Right? 2 cm
over back and
2 cm pre-stitch wound over left lower back. Then 3 cm fresh stitch wound.
otherwise.
One is, you are not required to submit on merit now.
Only thing is whether Milord, it can be Milord.
He gave it in second part, trial code,
Yes.
right? Trial code has 2. Imprisonment for life or as in hearing. So, one is under section 324, 2 years,
Yes.
326, 10 years,
10 years given.
307, life. So, Mr. Kosik, even we make it after say 302 with all the exceptions, if something is brought within the exception, either say exception 1 or exception 4, 304 part 1 or part 2, we generally give 10, 8, like that, instead of life.
Going by the, because there was an enmity as per the brother of the
It is not grave sudden,
great.
but some provocation is there.
Even
Belated, he acted belatedly, but some is there, both have admitted. Both the brothers, PW1
Yes.
and PW2, we had admitted.
Enmity.
So some, yes, some rage or grievance, to this man, he acted, definitely.
It was not without any purpose.
And secondly, ultimately, he has admitted. He had the occasion to give more blow on the vital part.
Yes.
At the opportunity, because nobody said that he was stopped.
But that is another thing also, but there were three people at that time. The owner of the house, other injured person. Actually, the enmity came between the two, one of the serious injured person and came into life. The other person, he got close because he tried to stop that or not because it's that person who got injured, although he was not active. Other witnesses say about that, but the thing is that the way he assaulted, the manner, the blows,
He left the place, but that man crawled into his house. It is not that he went after him. He left. It looks like from Tongighar he left. And that man crawled into his courtyard. Did not. It's-
in fact, I have seen that medical report. He was examined by the next day.
He admitted. No criminal antecedent? We'll look into that on the sentencing part.
So it was a perhaps case of, there was, perhaps proper cross-examination would reveal much more,
But
there-
what to do?
That is it. Because there is something, which amiss in the story,
We can't.
Well, I
kill
understand.
now.
Yes, but that cannot be done. No,
There was-
that I fully
there was
understand.
Action. Steps.
And,
We're not saying that he is not guilty.
and he did not inflict any such injury on the other person, even if it is not there, but then it was simple injury to the other person. So whether
But
the,
prosecution has failed to explain why you could not bring him. That part may go. If the prosecution is required to place the base evidence. And if not, there has to be explanation. Absolutely no explanation. I have gone through this case record. Absolutely no explanation. Why that man? Because he was released immediately on that day after medical treatment. He was a listed witness in the charge sheet for inexplicable reason. I have seen also this note because I know how PP prepares his case. Absolutely nothing.
well, he could have been even a vital witness for that. He could have-
This is the PP always, always. If they put like Savananda in blue, Jivan in red. Maybe something in his mind. What is this 161 statement? Do you have any idea? Hmm? Jivan. Santok. Jivan, The tree is, injury number 3 is perhaps correct. ঘাপ খাই সবানন্দ টঙি ঘৰত পৰি যায়।
That's not necessary.
ফলত সবানন্দে ঘাপ খাই টংঘৰৰ পৰা নদীৰ ফালে পৰি যায়। সেই সময়তে লগে লগে উক্ত শান্তকে তাৰ মানে মোৰ কপালত নে ক'ত ঘাপ মাৰে। ফলত ময়ো নদীৰ ফালে পৰি যাওঁ। পিছত মই তাৰ পৰা পলাই প্ৰাণ ৰক্ষা কৰোঁ। He fled away. First, Savananda,
he fell down.
many. আমি বিৰাট পাওঁ আমাৰ লগত থকা কথা পতাৰ চলে পুৰণি আখেজ বহত আমাৰ লগৰ সয়ানন্দ অৰিয়াক যধে মধে খপিয়াবলৈ ধৰে। ফলত সয়ানন্দ ঘাপ খাই টঙি ঘৰৰ পৰা নদীৰ ফালে পৰি যায়। আৰু সেই সময়তে লগে লগে উক্ত শান্তকে শান্তক তাৰ দ্বাৰে মোৰ কপালত ঘাপ মাৰে।
No, Santan.
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 Then he also fell down from Tongi Ghor. Then he fled.
So that better.
Fled
So they more
not to come back again. Never to come back again. Heard Mr. We'll close then. We'll think about the sentence.
This is.
Heard. Mr. M. Dutta. Laneta Michael Speaker, the appellant. And Ms. Sarah Kusit. Lanet, additional public prosecutor for the respondent state. Arguments I heard, yes, many citizens.
Obliged.
We'll not take other cases.
Why not, if your lordship allows me, in earlier case, I'd like to case for judgment regarding that.
Do it tomorrow.
Today is seven. Today is seven.
Okay,